Brooke Hall Carney. I'm a partner at Lipman Karas. We've got offices in Adelaide, Hong Kong and London. I was the first female principal there. I've been working with them for about 9 years. I'm also responsible for the technology portfolio, which entails the firm's network and its security, and in addition its litigation tools, for example Ringtail and Nuix. Prior to joining Lipman Karas, I was at Kingwood Mallisons in Sydney for about 9 years. I was in their litigation practice, dispute resolution practice, and learnt a lot of my skills there as a junior lawyer. I had some time off and did a Masters in Law at the University of British Columbia in Vancouver, where I had a Commonwealth Fellowship to study and teach first year property law. Prior to that, I started my career after law school at the Federal Court, where I was the Associate to the Honourable Justice Von Duser QC. I spent a year with him and then a further 6 months as the Research Assistant on the Ben Ward Native Title Claim in Western Australia. And following that, I was the Research Assistant for a further 6 months with the late Justice O'Loughlin, who heard the Cabillo and Gunner, or more commonly known as the Stolen Generation case. I have experience with quite a lot of the emergent technologies. Obviously, with the firm and its security, we're looking at cyber security. We're also looking at data and the privacy laws around the world, because we have an international network. In addition, the litigation tools that we use, like Ringtail and Nuix, they all use artificial intelligence to run through the data. So, for example, we act for a lot of liquidators, and one of the key assets of those liquidations can be the data. That's where we find whether there are any causes of action, negligence or breach of directors' duties. There can often be 12 terabytes or more of data. So we use technology to assist us navigate our way through to find the narrative or the evidence that we may need to use in litigation. So there are various sources of data. The data can be unstructured or structured. Traditionally, most data to date is unstructured. It's pretty much big data. Obviously, there's small data, which I consider to be anything that can sit on an Excel spreadsheet or in an Access database. Beyond that, it's pretty much big data, because you need tools to be able to understand it, read it and manipulate it. And then there's also dark data, which is sort of from the dark web. And there's long data, which is data that's been around for a very long time, and it has quite a lot of history to it. For example, weather data might be long data because it's got lots of history and mapping and sort of periods you can sort of follow and patterns. So most of the data is unstructured. It's not in any particular format. They're huge access email, PST files. So you have to have a source to deposit them in, and a way to search through them. So it's a bit like an ocean. You've got this ocean of data, but really what you want is the fish inside it, because that's the evidence that will be the narrative in your litigation. So we're actually sort of fishing in this big ocean, and we're using tools like Nuix, which has the artificial intelligence in there, but we're instructing it. We're actually instructing Nuix what to do. For example, we might instruct Nuix that we only want data between the period the 1st of November 1998 till the 22nd of November 2011, because that's the relevant period in the litigation. There might be a second set of rules that we'll put into Nuix to source our data. For example, we might like particular information from custodians, like the directors only, or the executive general managers, or the C-suite. So we're instructing and building that sort of AI search within Nuix to pull out the fish that we want out of our big ocean of data. And you look at your pleadings and the nature of the case to sort of identify what it is that you actually want to pull out. And although paralegals in our firm actually run the machine of Nuix, it's actually the lawyer instructing the paralegal what data they should be looking for. I'm the person who's saying, I want the data between these dates, I want the data of these custodians, I want anything that has this word in it, or truncated or Boolean sort of search words and those sorts of things. That comes from the lawyer. So in that sense, it's how you train the AI, and you need the lawyer to do that. And that's what we learn at law school. We learn how to think, and that's what we're applying by using the AI. So what we do is we access the data from the client, and we take a copy of it usually, and we bring it in-house and we process it within UX. Obviously in liquidations, the companies are usually defunct and the liquidator has access to all of the raw data, including the servers. But for a smaller litigated matter, the client will provide the data, or you go into their organisation and you do it within their organisation. I've just recently returned from America actually when I went to the ILTA conference, the International Legal Technology Association conference. And what I saw there was Microsoft sort of Office 365. What they've built into that Office 365 is almost an e-discovery platform, so that what you might find is a lot of this sort of paralegal work that's within law firms might actually be coming in-house. So that what I could envisage in the future is the lawyer is actually going and sitting with the client and sort of withdrawing out that data that they require from the Office 365 system. So there's a lot of activity happening in that sort of space to make people's data much better and much more structured. And one of the big catalysts for that is actually the GDPR, the General Data Protection Regulation that's due to come into force in Europe and Britain in May 2018, and obviously something similar here with the privacy laws due to come into effect on the 22nd of February next year. So organisations will have to be a lot more alive to what kind of data they have within their organisation. Everybody has personal data in their organisation because we all have staff, we all have a HR division, so there will always be personal data stored by the firm or organisation. It generally applies to organisations in Australia, I understand it, that have revenue of over 3 million. So if you're a slightly larger organisation, and you need to be able to ensure the privacy and respect of that individual's data that you hold. So there's a lot of regulation we're seeing in the market happening around the collection and the storage of data. What we haven't seen, and I think we'll see going forward, particularly with the involvement of AI, is we'll see a lot more regulation around the use of data, how organisations are using that data. So it'll be an interesting space to sort of watch, and we haven't seen anything in the US or Europe or Australia or Britain in that respect yet. So obviously we use Ringtail, which is a litigation database, and we work very closely with the developers of Ringtail. If we'd like sort of changes or searches, that gives the ability to search. It's also used within courtrooms as the actual platform for an electronic trial. There are similar products. There are many platforms like it, Relativity and many others. And then there's a lot more out there in terms of smart contracts. I think one of the biggest software is Kira, K-I-R-A. I know Mallison's in Sydney are the first Australian firm to actually bring it to the country. What's interesting about smart contracts is it has the ability to sort of disintermediate between sort of the lawyer and the person, because they can sort of automatically run, automatically search. So that sort of mundane contractual review work and management can actually be done with technology. So that's where you'll see a shift. We don't need a lot of contract managers. We don't need a lot of juniors in law firms to be analysing, 15 different contracts to extract out sort of clauses and how they may have changed, because you've got that sort of software. And that's also using AI. What's the intelligence behind that is the artificial intelligence. The other one that's very strong in the market in Australia is ones in relation to due diligence. For example, in mergers and acquisitions, we're seeing there's two products that are quite good. Luminance, which I think was developed by Gilbert and Tobin, who are very good in this space, is being used quite a lot in Britain and in Australia.
How's that used?
So instead of having a due diligence room, if you're sort of having a merger between two companies or a buyout, We used to have sort of 10 poor junior lawyers sitting in a due diligence room where they're literally going through all the various contracts, all the various business documentation, corporate documentation of a company to sort of identify where the risks or the financial issues are in relation to that company before they actually go into any formal merger and acquisition arrangements. But what we can now do with products like Luminance, there's another one out there, and Sarada I think is the other, is you can use this software to put everything in electronically, and using AI you can extract out the same information in such a small period of time with literally 1 or 2 lawyers dictating to the system what it is you're trying to investigate in your due diligence. So that's where we'll see quite a lot of shift, is in that sort of lower level mundane tasks. I don't think we'll need to be able to use junior lawyers to be doing anymore. And obviously there's disadvantages and advantages to that, because I think as a junior it's really good to learn what you're actually doing and you understand the point of it and where it's going to. And you can cut your teeth on a lot of stuff, and you can understand by the time you progress up the hierarchical chain what the purpose of it is. So we'll lose a bit of that training. The same with disclosure in litigated matters. We don't need a lot of people to be reviewing documents anymore, because most data is electronic, and we can use predictive coding, which the courts are now approving, which is an AI form of coding documents. So we don't need lots of young lawyers to be reviewing documents, but at the same time we're losing that ability to train them in terms of privilege, what to look for, and the different types of sort of data. But it may be that we'll just be training them in a different way on the technology platforms, and it could be them that are training the AI ultimately. At this stage I don't envisage junior lawyers to be training the AI systems. I think really what we, particularly with the predictive coding, we'll be using more senior lawyers, because you take a sample set, or a seed set it's often called, and you're training that sort of data set, and you're teaching the system that anything that has this kind of language or context is privileged. So you need a sort of more advanced or senior lawyer to train that sample set, and it's quite important. And obviously the volume of the sample set is also important. If we're talking about 100,000 documents for review, a sample set of 500 is clearly inadequate. You want to be hitting sort of 5,000 minimum as a sample set. So there's a lot of opportunity for juniors to work with the more senior lawyers to understand how the AI is being taught to operate in that sort of instance. I think probably one of the disadvantages of that is we'll actually also see a lot more interlocutory litigation, or applications by parties in litigation. What you'll see is people are challenging the sample set that they've prepared, who prepared it, how did they train it, those sorts of things. And as litigators become more sophisticated, they'll realise that there is a great opportunity to challenge, I think, at that level. And it's also very important because we're seeing the rules with the courts changing in relation to disclosure and data. This concept of proportionality is emerging from a lot of the cases in the courts all around the world. It began, I think, in the US, but it's definitely prevalent in Australia and Britain now, where it has to be proportionate to the claim. So, you know, if you're spending, I think just recently in Victoria, a judge scolded the parties in the Viterra and Cargill matter. I think they haven't even got to closed pleadings. They've already spent $3.5 million on disclosure, and it's a $30 million claim. So query the proportionality in that matter. So that's quite important, that proportionality. I think Chief Justice Bathurst in New South Wales recently has moved towards developing an online court for banks and mortgagees, so as a dispute resolution mechanism. And I understand that the banks are open to the idea of engaging with the court and developing that sort of thing, and I think that's terrific. Access to justice is expensive, and it's particularly expensive for the mortgagee when the bank comes after you. So that's a terrific initiative if they get that off the ground. I think what we've just recently seen, only last week I think the Supreme Court in the US announced that all of their filings have to be online. It's all publicly available, so there's no more searching or paying at a registry, those sorts of things. I think the South Australian Supreme Court sort of rolling out new electronic filings. So we're seeing a much more digitised environment that we're working within, not just within our courts and legal profession. We're only catching up, I think, in the bigger, broader business and social community. It's already digitised, so we need to catch up within the profession. I think the legal profession has probably been quite slow with innovation, and I don't think there's ever really been an incentive within law firms to innovate fast. I mean, the reward model or the incentive model within law firms is obviously the billable hour, so there is no incentive to sort of innovate or use technology. But I think clients are sort of really pushing it within law firms now. They're demanding sort of cheaper, faster access. We've got general counsels that are much more cost savvy and have budgets that are pushing for better solutions. So we're seeing a real shift, I think, in the legal profession. And we're seeing new types of legal providers emerging within the Australian market. This idea of the traditional hierarchical law firm is really starting to be challenged. You know, we've got Lex Voco, I think it is, where you've sort of got lawyers online that are working remotely into them. In fact, I know they're looking for a lawyer actually in Adelaide at the moment. That's a terrific initiative. The CEO of that's ex-Mallison, so that's why I know quite a bit about it. I worked with him. We're also seeing just last week, I think, in the US, the new model, I think it's called Atrium. So it's this new model of lawyers and technology sort of people, basically technology engineers who can code and build things. They've become sort of a law firm in their own sort of right. So we're seeing this quite a real shift in what the traditional law firm might look like. There was a firm about 10 years ago in the US that was also of that same sort of genre, you know, technologists and lawyers sort of combining together, but it didn't do so well. I don't think the market was quite ready for it yet, but the market is definitely ready for it now. So it'll be interesting to see how Atrium goes in the US and whether something similar comes in Australia. The other thing we're also seeing is a lot of consulting firms becoming quite strong legally. You know, you're seeing PwC, KPMG, they're pushing into that legal market. They're building their own sort of legal professionals within their organisation. So they're looking to compete against the traditional law firm that we're sort of used to. So there's a massive dynamic shift within the legal market, I think, and in the next 5 years we'll see that really sort of iron out a little bit. I think at the Future Forum actually in October this year, is it Dr. Bob Murray? The name of his firm escapes me at the moment. I think it's Frontier Murray or something like that. I'll look it up and send it to you. But he's suggesting that there's going to be this real change in the type of the law firm. He thinks there'll be much more consulting type law firms, and that the traditional hierarchical law firm won't exist long term. So it'll be interesting to see what he has to say at that Future Forum in October. Well, I think one of the things about the consulting model, if you look at Atrium as an example, one of the things that frustrated Atrium, because it's developed by a guy from Silicon Valley, who's a serial entrepreneur and has done very well selling his sort of technology. But what he discovered was one of the difficulties was access to lawyers. He would get these extraordinary invoices and he couldn't justify or understand where the cost had come from. And the same with buying and selling his software. So this is how he's come out of Silicon Valley to develop his own. And I think one of the things that he's really focusing on in Atrium, which might be where the consulting model may do very well, is he's looking more at fixed pricing. So for example, the traditional hierarchical billing model is that incentive of the billable hour, you bill the client by the hour. Whereas what he's doing is he's creating an estimate. My understanding is they create an estimate of the time required to do the job, and then they bill you on a monthly fee for that period of time. So it's a fixed fee basically. So it's a completely different model in terms of billing. It creates a much more collaborative environment as opposed to a hierarchical environment, you could say. And he's also using his technologists within the company to do the mundane tasks and make them very fast. So it's an interesting model in that respect. Yeah, I think it's a terrific thing for access to justice. I think one of the terrific, he's also sort of Silicon Valley. I think he was educated at Stanford. His name also escapes me, but he developed the Do Not Pay app, which is like a little chat bot, and you talk to it, and it will talk you through how to get out of your parking fines in the UK. It's been terrifically popular. I think he's helped 150,000 people. He's now developing more into a broader sort of legal sphere as well. So that's access to justice for people and it was free. It was totally free. He didn't charge to access that platform. And now he's venturing out into other areas of the law. In addition, I think there's some law students at Melbourne University earlier this year that created this online website for people, which was free, in relation to employment rights and a bunch of other sort of things. It was directed at not-for-profit and lay people. So there's a terrific opportunity for people to have access to justice at a lot cheaper rate. What does this mean for junior lawyers? I think it's really exciting. I think there's a lot of scaremongering out there. You know, if you listen to people like Elon Musk, you know, AI is here and we're doomed. But I think it's really important to understand that what you learn at law school applies in every facet of every technology around. We're seeing it in antitrust law or competition law as we know it. You know, we're seeing the power of Amazon, you know, market power. We're seeing it in directors' duties. I think we'll see a real change given cyber security. I mean, risk is really important for organisations. Cyber is a big risk for organisations. You can have share price go down, you can have a decline in product, you can release people's personal information, there can be insider trading as a result of cyber. So there's a huge, in every facet I think you still need law and you still need lawyers. AI is only as good as the people that are training it. It's not sophisticated enough yet to act as a human being, so they need us and they need lawyers to train them in the way to think as a lawyer. So that's important. I think one of the good things is they'll probably never have to do the mundane tasks that I spent a good 5 years of my early career doing, where you really are locked in a room and you're literally reviewing documents for a disclosure and you're making a list from document after document out of boxes. That doesn't exist, that won't exist anymore. That's not such a bad thing. We get more of an opportunity to actually be the lawyer, which is why we went to law school. What I would love to see in the graduates that are coming through our firm, we get very clever graduates. They are very clever. But I would like to see some real practical skills in how you might apply or how you might develop AI to be better. And often that creativity within really clever people can be missing because we haven't trained them to do that. We just train them specifically to regurgitate the law to us or analyse the law. What we need to also encourage them to do is to look at how we might make it faster, more accessible, cheaper for clients, and how we might apply some kind of business acumen to it. It's got to be worthwhile to the client. They don't want a 15-page advice on the analysis of the Charter Bridge law. What they really want is the 5-page advice on that and how they can specifically employ it within their organisation to make it effective. And if you can use technology to do that, clients are really happy with it. I'm not a computer scientist, but if you can understand data, which I do a lot of, I think that is very useful. To think about how you can collate information is very useful. For example, a client may give you bunches of unstructured data and seek your advice in relation to competition. You can't actually give that advice on the competition law and the market power if you can't access their data. So it's really important to have the creative mind to be able to get in there and fish out the fish from the ocean they've just given you so that you can produce the relevant and useful commercial advice to the client. The other thing is, I think AI will be trained by lawyers to be useful for lawyers. And I think in any aspect of our life, technology really reflects the value of the creators. So this is where I think there'll be this huge sort of ethical debate going forward. We're already seeing it with man versus machine. And I think there's a lot of opportunity there for young lawyers who have that ability to, if they can code, but also to be able to structure data in a way that makes it useful for the advice going forward. That's what I'm looking for, is those sort of practical, creative skills in combination with the legal and law. Legal and law is very important, and we still require it. I think this scaremongering about AI is nonsense. I think the way you apply it and the way you access your client's information will change, but you still need to be able to apply the law and know what the law is. So it's a real combination now. It's not just sort of pure law, I think, going forward. Yeah, so I think at the moment the market is probably in a little bit of a divide, where you've really got sort of more senior lawyers who don't really know about the technology, and then you have sort of people like me that might sit behind them who run all the technology for them. But what we're seeing is a lot of law firms at the moment, to bridge that gap, are teaching lawyers to code. For example, Kingwood Mallisons in Sydney is teaching its senior lawyers to code. It's terrific to have smart contracts, but you need to be able to get that information into the contract to make it operate as a technical tool. So someone needs to code that data, and you really need the lawyer to be able to code that. And then the other one is obviously blockchain. We're going to see big interruptions with blockchain, and that's going to really disintermediate sort of the lawyer and the product quite a lot. But there's a lot of regulatory issues in relation to blockchain, so lawyers are going to be required for a very long time to deal with that, I think, and that's very much in its infancy, the blockchain. It's really a shared ledger, and it takes out the middleman. This is oversimplifying it in a very pragmatic approach. So take the example where you buy and sell a house. You go to your solicitor, you get your conveyancer, then you go to the land titles office, you check that it all marries up, and then you exchange your money and it's all done. You don't need that with a blockchain. It can't be altered, the blockchain, and it's permanently there as a record from the very beginning to the very end. I think one of the greatest areas for blockchain is art. You know, if you could sort of trace that Picasso sale from 1840, or Rembrandt probably, 1850, all the way through to now, it makes it very hard to have fake art in the world, because you've got this sort of, this ledger that really is impenetrable. But there is a lot of law surrounding it. Obviously, it's got to be a shared ledger, so it could be all over the world. So there's a lot of regulation and a lot of legal issues coming out of that. I would encourage students to learn about blockchain. I think it has a very big future in the world. That's where I see law going. I see law going in a different sort of avenue to what we're traditionally used to. And unintentional consequences is another area that we should be sort of looking at. The person that develops the technology obviously has the intention that they're sort of putting into it. But it's only as good as whoever builds it. You know, the AI body or the machine is only as good as the person who puts the information into it. And I think there could be a lot of unintentional consequences of things that are built. Yeah, so it'll be interesting to see whether sort of things like discrimination or racism or things like that end up coming into these sorts of AI tools out in the general marketplace, because they're being built by these people who may have a bias, creators who are creating things with a bias. So there's I think there's lots of ethical issues out there in terms of unintentional consequences as well. So if a graduate came to us and we had to interview them, obviously we would do the normal sort of things, team building, those sorts of things, but I'd be really interested in their extracurricular activities. And one of the reasons for that is it kind of shows some kind of creativity, exposure to thinking outside the square, because often with these technologies you need, or these issues that we encounter with our unstructured data and trying to get out what we need for a client, you have to be able to think outside the square. What about if I search for data with this date, these time periods, and use this kind of language? And I think the more you're exposed to, the better you are at that kind of creative thinking. with relevance to obviously the legal problem that you have. So that's quite important to me. I think there'll be a lot more collaboration amongst lawyers and teams in what they're sort of doing, particularly in training AI and systems like that. So teamwork's obviously really important. The ability to work in as groups. Obviously social media is a tricky one. It's a very big issue at the moment in relation to my practice. We obviously have disclosure for a lot of clients, and social media is being used quite actively now. So an understanding and those sorts of things at the moment are still quite important. I think as what we'll see coming through is it's just part of everyday life. I have a 10-year-old daughter who can code and build games and do all those sorts of things. It's just part of her life. But at the moment, I think what we're seeing with graduates, it's part of some of their lives, but not all of them. So we've still got perhaps another sort of maybe 8 to 10 years where we're bringing those people through the profession, where we need to be able to develop those sort of creativity and coding skills, and we need to train for them. But I think after that, the people that are coming up through schools at the moment, it's part of their everyday life. I mean, you can see a 2-year-old swipe an iPad to open it now. Yeah, so it's quite different. I just think it's the part of society that we're in now and the generation we're in. I think client management is a big part of it now. I think that's really important. There's been a huge shift, I think, in the legal sphere, in that traditionally, when I first started practice, clients would go to a firm. For example, Telstra would go to Mallisons, or BHP would go to Ashurst. That doesn't occur now. We've got much bigger in-house teams in organisations, and what they're doing is they're going to a person. So relationships are very significant. Telstra might come to me if it relates to data or privacy, but they might go to Mallisons if it relates to a large piece of market power litigation, because that's the best guy to go to. I don't think there's this monopoly in the legal sphere anymore. So client relationships are really important, and being able to work collaboratively with the client. For example, Freehills recently, and they've just won an award for it at the International Legal Technology Conference in America. They worked very closely with Telstra's in-house counsel, and they built this technology or software to assist them in legal advice. And essentially, the bottom line is they saved 40,000 hours of legal work to be done by Freehills. So Freehills have given up that money, but what they've done is they've worked very closely with the client to develop that. So what we're seeing is this huge collaboration between clients and lawyers, and I think it's only going to develop further going forward. So that ability to have sort of client management, client skills, work collaboratively, teamwork is really significant. I think we could have more technology sort of based subjects. Not in the sense of just teaching students how to code, but in sense underlying how it works into the law now. For example, blockchain, what are the regulatory issues in relation to that? What are the issues? What are the ethical issues in relation to that? Directors' duties, what are the technologies that should be concerning directors' duties? For example, cyber security and risk is probably under Section 180 of the Corps Act, you could probably be liable as a director, and even ASIC has recently written that they consider it to be a director's duty. Market power, which I mentioned before, in relation to big technology companies. So what we're seeing is, you know, the big 5 technology companies are, for example, in the US, they're not traditional companies as we know them. They're actually unicorn almost companies. You know, they're Microsoft, they're Google, they're Facebook. These are the top 5. Australia's not quite there yet. Ours are still the 4 banks, although we've got Atlassian, but they're listed in America. So there's a real shift in that sort of area. So I think it would be good if law schools could encourage that kind of, firstly, creative thinking, application of the law to all of these technologies. I think technology is a platform in this digitised world that we work in, and we need to be able to apply the law to and risk and ethics, and build the systems in that sense. I think there's a whole world coming for ethics. I don't think regulation has kept up, or governments have kept up with the development of technology. I mean, in 1960, I think it was Moore's law that said every year computer power will double. I mean, when you look at sort of where we are this year to where we are next year, it's exponential, the growth, and we're not keeping up with it. We're seeing laws coming out now in relation to collection and storage of data, but really what we should be seeing as fast as we possibly can is use. And we're seeing cyberbullying laws not really keeping up with where they're up to. I think there's a lot of scope for the development of those sorts of legal issues and law. There's a huge scope for the law schools to be having sort of a legal ethics subject that's really canvassing these sorts of policy things, which are going to be big going forward, I think, for both communities and governments. With people building AI systems, you know, is there bias coming into it? You know, their discrimination, or you know, what data are they using for facial recognition, for example? There was a suggestion in the US that with the facial recognition AI that's being built, they're using a lot of historical data, historical faces, to teach the machines. And what they've found is particular races are coming out looking like a gorilla, or you know, particular sort of style eyes might be coming out looking you know, with a particular sort of trait. So those unintentional consequences are coming from the bias of the data that we already have. So there's a lot of ethical issues surrounding the development of the AI, I think. But you know, AI has been around a long time. It's just got a lot of hype now. I mean, we've all used Photoshop. That's AI. You know, you change one colour and it develops around it. These are actually artificial intelligence in a less sophisticated manner in there. I think one of the important messages that I send where I work and in any panels that I sit on is, you know, until you actually use technology, you don't actually get it. You know, you've got to be in it to understand it. And that's one of, I think, the important things for law students, is to be understanding how the technology operates, you know, where the encryption sits, as to who owns the data and those sorts of things, because until you know that, it's difficult to apply the law. And then the only other last thing I had was this quote that I often use on the very senior litigators within our firm. He says, "Do you have an alternative?" Of course, there's always an alternative option, and in law it's called irrational rejectionism. And it's described in the book Tomorrow's Lawyers as the dogmatic and visceral dismissal of a technology with which the skeptic has no direct experience. So I think what it's saying to lawyers is you can ignore technology at your peril, and it's saying the same thing in the business and the communities that we live in. And for any organisation, regardless of size, I think you cannot use or protect data if we don't know where it is, what it is, how we're going to get it, how we're going to use it, and what actually has value to the business or client and what actually doesn't. So that's, I think, really important to understand before you can even apply the law, is to understand the source of what we're analysing or looking at.